Good morning and welcome back. Let me introduce Judge Evander, who has taken Judge Cohen's place. Be seated. All right, the next case we're going to take up this morning is DIMILLO versus BB&T. So we're ready to proceed whenever the appellant is.
Good morning, judges.
Good morning.
May it please the court. I'm Robert Higgins, and I'm here with Allison Perez. We're with the Lowndes, Drostic, Doster, Cantor, Reed firm in Orlando, and we represent the appellants in this matter. We have filed an appeal of a summary final judgment of foreclosure below. We've raised multiple issues of procedural and substantive law, which we feel the trial court erred. And if I may, this matter goes back to 3 loan facilities entered into by the former Colonial Bank and Mr. DIMILLO and his companies. He's in the business of building single-family and multi-residential homes in the Osceola County area. First loan was for acquisition. Second loan was for infrastructure work and permitting. And the third loan, which is important to the Dench-Doom argument that we're making, was a loan for construction of particular units. There came a time when Mr. DIMILLO wished, and a loan agreement was entered into in connection with Loan 3. And that allowed for the construction of 2 spec houses and a modular unit for townhouses. There came a time when he wished to change his makeup of his houses because he wanted to get a better price point for his product, and he asked the bank to modify the loan agreement slightly. The modification did not put new money into the loan. It simply changed the type of houses he could make. He talked to Jacques Coulard at the bank, who was his representative at the time, and Mr. Coulard agreed and prepared a memorandum, which was then signed off on by 2 senior Colonial Bank officials, Weaver and Loesch. And as Mr. Coulard said, that was to be put into the bank records. Later, when Mr. DIMILLO wished to draw down on the line of credit for his new construction, the bank denied the line of credit, or the funding. And the person then assigned to his loan at the bank, a new guy, talked to Coulard, and Coulard sent an email which verified that, in fact, there had been a memorandum, there had been an agreement to change the terms of the loan document to allow for the construction of for the townhouse units. And all this is in the record. It's uncontroverted, I think, that these things occurred. The only thing that is controverted is that Colonial Bank, and now BB&T, says they could not find the signed memorandum. That goes to the issue of the Dench-Doom. If I could, but first we raised the issue, Judge, of the procedural errors at the trial court. And those errors were allowing the summary final judgment be entered without proof that BB&T was in fact the owner and holder of the note and mortgage being foreclosed, and that counsel for BB&T had authority from the FDIC to use the Dench-Doom defense in his case because we had filed counterclaims and affirmative defenses. The issue with the...
Well, let me just ask a question about that last point.
Yes.
Somewhere in the briefs, it's referenced the position that Dench can't be used unless FDIC has given its permission.
Yes, sir.
See, the way I read that, it says, it doesn't give any parties, there's no judicial review of that. In other words, that may be their policy, but
yes,
it doesn't create any rights on anyone's behalf. And so let's assume that that's their policy. Yes. There doesn't seem to be any dispute. And let's assume that they didn't get permission. Their own policy seems to suggest that, there's no judicial remedy and that doesn't create any right in your client.
And that may well be, Judge. But what we do have here is we have a valid counterclaim and valid defenses which we feel cannot be overcome by Dench Doom. And before counsel for BB&T could use that to overcome our counterclaim and defenses at the lower trial level, he had to have that authority. He agreed with that because he brought to the summary final judgment hearing an email, which was unauthenticated, from some guy at the FDIC saying, go ahead and use these defenses. So he felt that was the case. We've cited the case from another jurisdiction where the BB&T says they know they have to do this. They have to get the FDIC approval because Dench is a big club that can be used by banks to beat down claims. And we felt as an initial proposition they had not reached or crossed that threshold where they had the authority to do that at the trial court at that level for the summary final judgment purposes. And on the issue of the ownership of the loan documents, the notes are not endorsed to BB&T. There's a statement, Mr.
They had the originals, though, correct?
They had the originals, but they were still in Colonial. There is an affidavit from Mr. Shields saying that these were assigned, but we went behind that and looked and saw that there is no book and page, as he said in his affidavit. We filed a counter affidavit contesting that. Counsel then brought to the hearing again the unauthenticated assignment, but that was not served more than 20 days prior to the hearing.
But they contend it was just a typo as far as the book and page number.
Right.
I mean, is there any serious dispute about the assignment? I mean, is it a typo or is it not a typo?
Well, it may well have been a typo.
But there is an assignment in record.
Yes, there is an assignment, yeah, but that was not...
It seems to me that what's important is whether or not there's an assignment, not whether their typist got it right.
I can't contest that, Judge, but still that should have been attached to the affidavit, and that should have been served more than 20 days prior to the hearing. It was not. And that's uncontroverted. I'm seeing cases almost every other week in Florida weekly where appeals courts are reversing cases because people don't have their paperwork right. So that's the issue.
Well, assuming there was no typo, would the affidavit with a reference to the public records have been sufficient?
That's, I guess is back to the issue that the panel was hearing before this case, the business exception rule. I take the position if you mention a document, you have to attach it. And he should have attached the affidavit, or I'm sorry, the assignment to his affidavit going forward. And I think that gets past any hearsay rules if they do that, but they didn't do that in this case. On the substantive issues, again, and I understand because I'm usually on the bank side in these cases, and I can tell you that I know that Dench is a big club and you can really beat people up with Dench. But we feel in this case, this is not a case where we have a deal that a banker was making on the way out the door. The bank is going down, he's making brother-in-law deals, he's helping his buddies out, he's releasing guarantees. We don't have that here. We have a deal, we have a loan agreement made by a bank, and Mr. DiMillo was drawing down that loan agreement properly.
Is it true your client never signed the agreement? Is that correct?
Well, he did not sign. Oh, he did not sign the memorandum.
The memorandum.
Yeah, but
that's all there was.
That's right. We take the position we have a loan agreement, which is a valid document in the bank's records, and it was amended, and we have testimony from BB&T's people and the former Colonial people that the manner in which they did it was proper under Colonial procedures to amend the loan document. And again, there's no new money, there's no new obligation. It's just simply we're going to build this kind of house rather than this kind of house.
Okay.
So we have that, and that's corroborated by Jacques Coulard in his email that we have put in the record. We feel that is enough of a question of fact that the trial court should not have just glossed over that and should give us our day in court to argue that in fact we have a valid amendment to the loan agreement and the Dench Doom should not be used to prevent us from making our arguments going forward. In fact, there's testimony in the record that the appellants were current on their loans when the banks stopped funding the loan. The bank was going down, and they probably just froze up and stopped on everything. That's just an observation on my part. But we have we raised several other issues about the judgment. One of which was there was a mysterious $52,000 increase in the amount of principal that was set forth in the complaint in Mr. Shields' affidavit. Again, maybe just an error, but that's still a question. And we raised this issue and many of these issues in our opposition and memorandum of law that we filed prior to the summary final judgment hearing. So all these issues were out there on the court. And there's a substantial issue on the amount of interest due.
May I ask you to just go back to there doesn't seem to be a dispute about Colonial's folks approving changing from, I guess, single family to multifamily or townhouses or something. But when we look at the Dench doctrine and I agree with you, it's a gigantic club, but it is what it is, unfortunately. And, you know, if I understand the loan agreement in this case, the loan agreement said you got to build, I guess, single family. And he wants to convert to something that is not permitted by the loan agreement, so he needs to amend it. But for the fact that the bank went under, we wouldn't be having this discussion.
Yes.
But the bank goes under. Doesn't Section 1823 require specifically that the document be signed by both parties? And hasn't that been interpreted, at least in the federal court, to mean that both parties means both parties? Not just the party. It's not a statute of frauds.
Right.
Because it's not just by the party to be charged. It says both parties, and they said both parties means both parties.
Yes, sir, and I agree with that. If we were making a new deal, a new arrangement, a new procedure.
Well, but you say this isn't a new deal. It isn't a new deal in the sense that there's new money, but it's a new deal in the sense, at least it could be argued it's a different deal in the sense of, instead of doing single family, we're going to do multifamily or high rise or whatever it's going to be. It's a change deal. There's no new money, and there's no change of terms as far as interest and that sort of thing.
Right. That's right.
But I guess what I'm trying to understand is the fact that there was a need to amend the loan agreement. Doesn't 1823 then suggest, and hasn't it been interpreted by the federal courts to say that it's got to be what parties means both parties? And I'm not sure that's the way I would interpret it, but that's
Judge, we have looked for cases like ours. We could not find a case like ours, but I fall back on this. Under bank procedures, they could make, it was called a minor modification. It was not a major deal. They could make a minor modification by a senior vice president and had executive vice president.
And I agree. Had the bank not gone under and Colonial had locked up the money on your client, we wouldn't be having this discussion. But they didn't, and I guess the problem is whether 1823 just it clubs you.
Didn't they? Maybe I got it wrong, but it seemed to me that Colonial was still cooking when he wanted the draw. Is that true?
That's correct.
And they didn't, and they wouldn't give it to him.
They would not.
They said, "Well, no, that's interest reserve and all this other stuff."
Right.
So the default really occurred before they failed.
That's correct.
So then they failed. FDI, then BB&T. Then BB&T asserting, "Hey,
that's right.
Dench doing."
Yeah.
Okay, that's what I thought.
Yeah, we feel there's a question of fact whether that the court should have not have just glossed over that during the summary judgment hearing. It's in reality, minor modifications are made to bank loan documents every day with initials, and they're put in the file. And it's the poor guy who's done nothing wrong later in the day that comes along and gets hit on the head with it.
But Dench doesn't
when he was
that
not. Yes, sir.
I mean, that doctor doesn't make a distinction about.
I understand.
It really was for the purpose. You said, the sweetheart deals and all the stuff at the end.
I understand, but it's just I can't argue fairness on it, but it's just not because banks don't do that way. Banks do.
You're right.
Yeah, banks don't bring people in to sign initial every time they make a minor modification to a loan document. So we raised issues on the amount of interest due because the Shields affidavit covers the long time period. We raised the issue of we challenged the interest in our opposition motion, and so they came to the hearing and said, well, we'll just make the default date from here, because they hadn't alleged the default dates. We couldn't tell what the interest was. So the complaint just says interest. It doesn't say from what point to what point. And then the order was, the summary judgment was entered without any additional proof showing the amount of interest due during the periods that they agreed to take the interest from. So again, an error on the court. And we think the trial court misunderstood and misapplied the Florida credit statute to hold that our counterclaims were barred based upon the statute of frauds. It's not, because, and our affirmative defenses, I'm sorry, because it's clear that the affirmative defenses are not barred by that statute. I have 5 minutes and 14 seconds. If I could take a few moments,
Sure.
reserve those. Thank you.
Yes, sir.
May it please the court. My name is Jason Rosenthal of the Rosenthal Law Firm. I represent BB&T. First, I want to clarify the modification we're talking about here, and there is new money. The original loan agreement provided for spec houses, meaning houses that will be built that haven't had people pre-purchase them. And under this loan agreement, on spec, they could build two single-family homes and 1 4-unit townhome. The change that the appellants are suggesting was agreed to by the bank, which actually is disputed but not material for summary judgment, is that he wanted to build an additional 8-unit townhome on spec. This isn't just a change from we're going from single family to townhomes. This is we're allowing you to build more things that you haven't sold yet, that might never be sold, so that the bank's going to be funding on a building that might not ever be sold. So that's not a minor modification. That's a fairly significant modification.
So it was going to be 12 units total, or did he just want to build 4 more?
He wanted to build 1 8-unit townhome.
Okay, instead of the 4 and the...
He already built the 2 he already built what was allowable as spec.
Okay.
He already built the 2 single families,
Okay.
and he already built the 4-unit townhome.
Okay.
What he wanted to do is build another building on spec.
Okay.
Which would have required an amendment to the loan agreement. There is no dispute that there was never a modification signed by both parties. There's actually a dispute whether the memorandum exists. The affidavit of Mr. Shields says we've looked through our files. We've never seen such a memo. The testimony from the senior bank officials would be, if this was presented in a memo and I would have signed it, that would have been a way the Colonial Bank could have dealt with this modification. But the memo has never been found.
Well, but when I look at the evidence, I think we can dispute perhaps what the significance of it is. At least for summary judgment purposes, they seem to have enough in the record that would suggest that Colonial Bank did agree to that modification.
I agree.
Now, I think that we can dispute whether it makes any difference or not. But if all we were talking about is there any evidence in the record to suggest that they modified, it seems to me that there is.
Correct, and I just wanted to let the court know that we do dispute that, but for purposes of summary judgment, the issue under 121823E is whether it was executed by both the borrower and the bank, and the undisputed facts are clear that it was not. Mr. Couillard said that it was an internal, when I asked him, did you provide a copy of this memo to Mr. DIMILLO, he said, quote, hell no. And I said, why? He said, because it's an internal bank document.
I understand you have the language of the statute to support you as far as both parties. Do you identify any policy reasons to prohibit enforcement if you were to have an agreement signed by the bank, loan committee approved it, et cetera, but for whatever reason it wasn't signed by the lender, but any policy reasons that would support your position here, or you just feel you're in good enough shape relying on the language of the statute?
Well, first thing I'd note, we've got the statute. We've got Langley versus the FDIC, where the United States Supreme Court said this is what Congress said, and we are going to go by what Congress said. I can put forth a policy argument that when you're dealing with these modifications in terms of a failed institution, you want certainty as to what these terms are. And how are you going to get certainty other than if both parties sign it and saying this is what was agreed to? Otherwise, it could be signed by one person, but then the borrower could come back and say, well, that's only part of the story, Your Honor. We said, yeah, we'd build another 8-unit townhome, but they also promised me that they would change the interest rate. It's certainty, and I think that's what Congress was looking for. I think that's what the statute says, and I think that's what the United States Supreme Court has said. The other issue, well, going to the standing issue. We have the original documents filed by BB&T. There's no issue of fact that on August 14th, 2009, the Alabama State Banking Commission
Well, didn't the defense agree to your substitution?
Exactly, Your Honor. And, the first time I was even aware that there was going to be an issue about this was when I saw the opposition to summary judgment. I said, well, come on, you guys, we filed a motion to substitute parties, and the motion specifically said because BB&T acquired these loans.
They didn't oppose, they agreed to it.
They agreed to it, they agreed to the order. That is a non-issue here. Get to the issue about the interest and what happened there. Again, for the first time in opposition to the summary judgment, I get an affidavit stating that, from the borrower, saying that I don't recall receiving the notice of acceleration. There were 3 loans, one of which matured, the other 2 were accelerated because of payment default. Now, under pleading practice, that should have been specifically denied when I alleged that all conditions precedent had been complied with. It was not denied. I didn't know that this was going to be an issue for summary judgment.
Denial?
Excuse me?
It was just a general denial?
I believe it's either a general denial or without knowledge. But the rule says if you're going to deny conditions precedent, you have to tell the person. And clearly the acceleration is a condition precedent. So here we are coming up on the summary judgment, and I've got...
and did these loans all have cross-default provisions in them? In other words, default in one as a default in all?
I'd have to go...
Sorry.
I imagine they do. I'd have to go back and look. I could not honestly tell you that. But I'm getting ready for a summary judgment hearing. I see, oh, wow, now we have this issue as to whether or not they received the acceleration notices. And it's not because the defendants or the debtors admitted or denied that they hadn't made the payments. The issue as presented is, well, we don't know when you can start accruing default interest, because that's going to be when you demand and accelerate. So, and again, this is something that should have been brought up in the pleading stage so that I could address it when I'm going to summary judgment. So what I did to move the case, because we have 3 defaulted loans, the bank wants to go and proceed with its remedies, I said, look, there's case law, Your Honor, that says, the Peachy case, that says you can accelerate through a complaint. And we did, and our complaint alleged that the loans were accelerated. So here's what we're going to do, Your Honor, say that's the date of acceleration, award us interest from that date going forward, in essence waiving months and months and months of interest from the date of the demand letters until the date of the complaint.
It was a waiver of the default, right?
No, we waived all interest. I didn't want any issues out there at all. And to get to the judgment, we said, Judge, we're going to do the acceleration on the date of the complaint, and you just give us interest from that date going forward. And that's all we got in the order.
So there was no prejudgment accrued interest?
There was, but it was waived.
Pre-complaint accrued interest?
There is, but it was waived.
Okay.
To deal with...
Same thing, you also waived the late payment fees?
And that's only for a matter of consistency, because if we're not charging late fees post-acceleration, they were beforehand, but if we're not putting into evidence when the acceleration was, it just seemed...
Their contention would be that would cause the loan to be usurious, but the court didn't award that.
The court didn't award that one, and, Your Honor, I went through the math in my brief. Even if you included those late fees as interest, you don't get close to the 25% based on what Mr. Shields stated in his affidavit was the accrued interest. Because there is a time where it was contract interest. When you blend the time where it was contract interest with the part that it was default interest, and you add in the very nominal late fees that were being charged, you don't get anywhere near the serious interest. And that brings another issue. Again, there were a lot of arguments here made on summary judgment that should have been properly pled, which were not. Prior to the summary judgment, I had no idea that usury was going to be an issue in this case because it was not pled. And the case law is very clear that usury is an affirmative defense, and it's a defense that can be waived, and waived if it's not pled. The appellate courts in the decisions I've cited said, if you don't raise an affirmative defense, we're not going to consider it on appeal. It was never raised. There was never a motion to amend the pleadings to raise these defenses. The complaint alleged the debt, the late fees, and that interest was accruing at the default rate. At that point, they could have alleged usury and done whatever they wanted, or they could have, before the summary judgment hearing, moved to amend their answer to seek to allege usury. None of that ever happened. I would note even at the oral argument on the summary judgment motion, usury was never referenced as one of the items to deny summary judgment. I think it was a one-sentence in their opposition to summary judgment. But I mean, the two important points on the usury are, one, wasn't alleged, and two, when you look at the math, there is no usury. The issue about the difference in the principal on one of the loans between what was alleged in the complaint and what was in the affidavit, this issue wasn't raised before the trial court in opposition to the motion for summary judgment. This was raised for the first time on a motion for rehearing. The trial judge, when the motion for rehearing was filed with the response, denied it. The trial court has the discretion not to consider new evidence or new arguments in a motion for rehearing, and it didn't. We could certainly have explained what that difference was, but it wasn't brought up properly. It wasn't brought up on time, and there was no counter affidavit saying, this amount is incorrect. With respect to the authority to raise Section 1823, there's nothing in Section 1823 that requires the assignee from the FDIC to put that in as part of its prima facie case. On summary judgment, I have to put forth my prima facie case, and unless that's part of my elements, I don't have to put it in. If you accept the argument that we have to put in evidence of permission, then at any trial where 1823 was alleged, we'd have to subpoena somebody from Washington at the FDIC to come into court and testify that, yes, they gave permission. And that sometime during the proceedings, there'd probably be discovery asking the FDIC, well, why are you giving permission under these circumstances? I believe that's why they set forth in their guidelines that we're not going to let this be subject to judicial review. That these guidelines, while they are guidelines, do not create any right or benefit, substantive or procedural. Do not create any right to judicial review, settlement, or any other right involving compliance with the terms. I just don't think the FDIC wanted to be dragged into this when it's raised by litigants. Your Honor, I agree that this court's case law on the credit statute provides that it doesn't bar affirmative defenses. It only applies to counterclaims. I don't know if this would be the test case to reconsider that issue, but on tipsy coachman, it doesn't matter. There are plenty of grounds in this record because 1823 by itself eliminates all the affirmative defenses and counterclaims. And unless the court has any other questions regarding our arguments, I'll sit down.
Thank you so much.
Please, the court. Just a few things to respond to Mr. Rosenthal's comments. We filed an amended answer after the substitution of BB&T, in which we said we were without knowledge of the ownership issue. So therefore, it was incumbent upon them to prove the ownership issue. On the standing issue, the fact that we stipulate that they can substitute BB&T for Colonial Banks, we don't have to send associates to Kissimmee for a 30-second hearing, doesn't mean they don't have to prove their case.
But I mean, if they had no standing, it would seem you should oppose that. What would be the purpose of having them in the case if they had those standards?
Well, Judge, I know that the FDIC takes over banks. I know that they sell.
I mean, that's not a real issue, is it?
Well, Judge, it is. I think because they still have to prove their case. They still have to prove that they own the notes. I mean,
They had the note.
well, yeah, but it wasn't endorsed, and the assignment there was no assignment timely served, and the assignment and the Shields affidavit was wrong on recording information. You know, without being flip, I could have substituted Tim Tebow as plaintiff, but Tim Tebow would still have to prove his case. That's the point. They still have to prove their case. And that's what the issue came up with. And as I said, we didn't have the opportunity to see the assignment because it was not timely served 20 days prior to the...
Do you need an assignment if there's agreement that BB&T is the successor in interest to Colonial?
You might not at some level, but some levels you will, because once it goes into the public records, if you don't have an assignment, it won't be recognized. I think the Florida statute, and I don't recall the statute, does require that there be an assignment of the document, either on the back, either endorsed with an allonge, or with a separate document.
Well, you might have different issues applied to third persons, but if Colonial Bank, if there's no dispute that they're the owner and holder of the note, and then there's no dispute that BB&T has become their successor in interest, which the trial court's orders said they were the successor in interest, you know, after the stipulation of substitution, why would you need proof of an assignment anyway?
Well, at some point, they will need that, because the Florida statute says to transfer a document, and again, I apologize for not having that you have to have an assignment of the document. It's got to be assigned. Now, it may be for internal FDIC purposes or for the bank's purposes that they say they own and hold those notes. But you see cases all across the country every day where people are coming in and they're not proving that they own the note and mortgage. Notes are put into these securitization pools, and they're transferred all over the country. That's an issue. That was the threshold issue that they had to have at the summary final judgment hearing, which they did not meet. Judge, we didn't raise usury as a defense because it didn't rear its head until we saw their summary final judgment package. We started to look at all the numbers, and it didn't add up. That's the reason they came and waived the months and months and months of default interest. And again, what we say is that there was no affidavit in front of the court saying this is the amount of money owed from point A to point B. I think that's a mistake, and I think there's no justification. The trial court did not have anything in front of it to make that determination, and I don't think the trial court even had the tools to make a mathematical calculation of the amount of interest, and because we submitted evidence that the bank was for a long time showing on its records that they were only charging contract interest, and the default interest didn't come back until a later point in time. So again, all of that's murky and was not proven up. And we did not raise the acceleration issue on appeal, but it's important because of the math in the case. How much could the trial court award, and did award the correct amount? I appreciate your time. If you don't have any questions.
Thank you.
Thank you.
All right, we're going to